All right, good afternoon, everybody. I am showing 12 o'clock on the dot, so we will go ahead and get started here. As you saw, the session is being recorded, just so you guys are aware. Welcome to our final webinar of our Special Asset Summer School Series. That always bums me out to say because it means that summer is coming to a close. But luckily in Wilmington, North Carolina, it will be warm for a lot longer. This class is led by Lily Faulconer and Norman Leonard, and we're going to delve into pre and post judgments. I'm Haley Cook, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try and troubleshoot with you. As I mentioned, this webinar is being recorded and it's for good reason. We post these on our website. So this is our homepage, and you can go to webinars, scroll down past webinars, and you're able to see both session 1 and session 2, and we will add session 3 up probably tomorrow. So please do take advantage of that or send it along to your colleagues. Our speakers are happy to take questions during the webinar. If you have a question, please type it into the Q&A box and it will be addressed at the conclusion of the presentation. Lily and Norm also have free reign to answer during. So please know if it's relevant, we might discuss it now or anytime. As I mentioned, our speakers today are Lily Faulconer, a creditors' rights attorney in our Greenville office, along with Norman Leonard, our creditors' rights and intellectual property attorney in our Asheville office. So we're kind of covering a lot of our office spaces today, but I'm going to go ahead and turn it over to Norm so we can get started.
Thanks, Haley. As Haley said, my name is Norman Leonard, and I do practice creditors' rights and bankruptcy law with Ward & Smith in our Asheville office. I also practice intellectual property law as well. I've been with Ward & Smith now for 14 years, and thank you all for attending our webinar today. Lily?
Thanks, Norman. My name is Lily Faulconer, and like Haley said, I am a creditors' rights and bankruptcy attorney in the firm's Greenville office. I also practice business law from time to time, but Norman and I are really excited today to dive into pre and post judgment rights and remedies with you. Haley, if you'll flip over to the next slide, I'll go ahead and share with everyone what they can expect today. We have 3 goals for today. We want to provide you first with an overview of considerations when you are enforcing your rights and remedies under a loan secured by personal property. Second, we want to provide you an overview of basic legal procedures and requirements for enforcing those rights in your personal property collateral. And then lastly, we want to give you an overview of basic legal procedures and options when you are working to discover debtor assets or enforcing your judgment. And so with that, I will turn it back over to Norm to start our discussion with loan document review.
All right. Thanks, Lily. All right. So first of all, before heading down the path of enforcement and even before accelerating your loan and declaring a default, it's a good idea for you to, when you're encountering a default, to take stock of your loan documents and assess your collateral before deciding how to proceed and determining that acceleration and enforcement is the right path. You want to take a look at your loan file, make sure it contains all the relevant documents, including all of the modifications that were ever entered into, all amendments to your security agreements, all releases of collateral and releases of guarantors that might have been executed, just to determine that your collateral is what you think it is, and that you have all of the documents that you're going to need to enforce your loan. And as soon as you've done that, then you want to take a look at your security interest in your collateral and make sure that you are properly perfected, that not only do you have a security agreement that grants you a security interest in the collateral, but also that has been made perfected via the filing of a UCC financing statement or the notation on a certificate of title for any vehicles or titled collateral, so that you can make sure that it will be enforceable against third parties or in bankruptcy. And this is the point at which it's often a good time to share your documents with counsel, whether it be in-house counsel or external counsel, to verify that you are indeed perfected as you think you are. Because determining all of these things are going to be critical to developing an optimal strategy to enforce your loan. All right, so once you've done that, and you have a full grasp on your collateral and your rights, in some cases, depending on the results of your initial assessment, you might decide that something other than acceleration and enforcement is better. If there have been problems with your loan documents or your collateral that you've identified as part of that initial review process, it might be the case that a workout or a forbearance agreement could be better. In the context of forbearance agreement, if you're granting your debtor an extension of time in which to pay the bank, or you're offering any kind of restructuring of their obligation or other consideration, then you can have them execute a forbearance agreement that will cure a wide variety of defects with your loan and with your security interest. You can have in the context of forbearance agreement, you can have your debtor reaffirm a security interest. You can have them grant you additional collateral if you're unsecured. You can have them cross-collateralize loans if the initial cross-collateralization wasn't done or was done improperly. And you can also have them release any counterclaims that they might have against the bank or your company if there has been any kind of bad blood in the past or any kind of questionable conduct. And many times, even if forbearance is not an option, sometimes you will want to delay enforcement to address certain issues, like if there is collateral that has not been properly perfected. You might find out that a financing statement was not filed in the correct location, or a vehicle title was lost, or not didn't properly note your security interest. And if that's the case, and you are able to take steps to remedy that and perfect that collateral, then you can do so, and then wait 90 days until any bankruptcy preference period has passed, and then proceed to accelerate and enforce your rights in your collateral. All right. With that, I'll go ahead and hand it back over to Lily to talk a little bit about claim and delivery and self-help repossession.
Thanks, Norman. And before we continue on this journey, I just want to remind you all that the topics we're discussing today and our viewpoints on this are not to be taken as legal advice. We are just giving a presentation of some things you can consider. Doesn't substitute for calling your attorney. And if we discuss anything today that seems like a factual situation that you're dealing with, please reach out to counsel and don't use this presentation as a substitute for seeking that legal advice. We're also going to be talking about North Carolina law primarily. So in some states, there are remedies available to secured creditors that are not available in other states. A really good example of this is wage garnishment for secured creditors. We don't have that here in North Carolina. But similarly, there may be things available here in North Carolina that aren't elsewhere. And so with all those disclaimers, we will jump back in and talk about the tried and true method of self-help repossession. And self-help repossession is one of two ways that you can repossess your personal property collateral after default, but before entry of judgment. And so a key, of course, is that there is a default. You can't just go repossess your collateral because you feel like it. But another key piece here is that you cannot breach the peace in your self-help repossession. And so what that means is that you cannot trespass. So let's say the property is locked up in a fence. Can't just scale the fence and take the property out. That is not going to be looked upon nicely by a court if your judgment debtor or your debtor at that time brings that issue up. And if they come out and say you need to stop there seems to be an altercation brewing, you want to just avoid continuing with that repossession to avoid breaching the peace. You can do this yourself, of course, or oftentimes, as many of you know, you can employ a repossession agent to assist you with that repossession. And you want to make sure that through that entire process, you are complying with Article 9 of the Uniform Commercial Code, which you'll hear us today refer to as the UCC. Haley, you can flip to the next slide, and I will contrast self-help repossession with claim and delivery. So the biggest difference between claim and delivery and self-help repossession is that self-help repossession you can do on your own. You don't have to establish or file a collection and possession lawsuit in order to commence your repossession efforts if you're working by yourself. But for claim and delivery, it requires that you have filed a lawsuit seeking possession of that collateral in order to proceed down the claim and delivery path. Another big difference that I will talk about in a few minutes is the ability to use force when you have a claim and delivery order. But what is claim and delivery? So claim and delivery is a statutory remedy that allows a creditor to remove its collateral from the possession of its obligor before judgment. And you can file claim and delivery either in conjunction with your possession or collection lawsuit, or you can file it after you have filed that possession lawsuit. It is a proceeding that will occur before the clerk. So it's separate proceeding from the rest of your possession lawsuit, but you are required to serve the debtor with notice of that proceeding. And so that's a reason sometimes that the claim and delivery pleadings are also issued in conjunction with the complaint, because you can serve everything all at one time. And the judgment, the debtor has to be served with those documents at least 10 days prior to a claim and delivery hearing. So if you have not served the debtor 10 days before the hearing, you'll need to reschedule that hearing and serve an amended notice of that hearing on the debtor in order for everything to be up to snuff. Like I said, it's a proceeding before the clerk, and a bond is required. So the bond is going to be twice the value of your collateral. So that's not twice the value of your loan. It's not twice the value of the collateral at the time the loan was made. It's the value of the collateral present day. What is that value? And your bond needs to be twice that. And so you will obtain that bond, provide proof of that bond to the clerk. An affidavit and request for claim delivery will be submitted to the clerk. That is typically completed by the attorney. And then the claim and delivery hearing will occur before the clerk. Sometimes debtors show up to these hearings and sometimes they don't. But if they appear at the hearing, the clerk will give them the opportunity to say why they're entitled to keep this collateral. And then the attorney present will let the clerk know that, of course, there's been a default, that the loan documents provide that the secured creditor is entitled to possession of its collateral upon default, and ask the clerk to empower the sheriff via an entry of an order of claim and delivery to repossess that collateral. And so this is when the second big difference between self-help repossession and claim and delivery kicks in. And that is when the sheriff has an order for claim and delivery, the sheriff can use force. In other words, the sheriff can breach the peace in order to repossess that collateral. And so while you may have to press pause on your efforts because the property is locked up, the sheriff does not have to do that. The sheriff can just break that lock on the fence and then walk on in and get that collateral. Something to keep in mind, though, is that you will need to work with the sheriff on storage of that collateral and coordinating when you can pick that collateral up from the sheriff. But that is something that can easily be accomplished once the sheriff is able to leverage that claim and delivery order to repossess the collateral. And so we've checked off self-help repossession, we've checked off claim and delivery, and I'm going to turn it back over to Norman to talk about a few other options pre-judgment.
Thanks, Lily. So the pre-judgment remedy that I'm going to talk about is called pre-judgment attachment. Pre-judgment attachment is a tool to secure a debtor's assets while a lawsuit is pending and before a final judgment is obtained. Essentially, this is a tool to prevent debtors from transferring, encumbering, or hiding assets from you before you have the opportunity to enforce your judgment. It's not available in all circumstances, but when it is available, it can be an important tool in increasing your chances of recovery. All right, so prejudgment attachment, when is it authorized? It's authorized in circumstances where you are filing a lawsuit in North Carolina against a defendant who is a non-resident of the state or a foreign corporation, a domestic corporation if the officers of that corporation can't be found within the state, and any person or domestic corporation that with the intent to defraud has or is about to transfer assets or remove them from the state. So what do all of these types of defendants have in common? Basically, these are examples of defendants who are or appear to be or could easily remove assets from being available to satisfy a judgment. So this underscores the purpose of this remedy is really to protect in-state litigants from opposing parties who are liable to remove property from the scope of eventual judgment lien. All right, and we're going to look at how prejudgment attachment works. So the process for obtaining prejudgment attachment can get fairly complex depending upon who your defendant is and what you're trying to attach. But we're just going to go over some of the basics here. So basically, when you're filing your lawsuit, you will file an affidavit or include allegations in your complaint to establish the requirements for prejudgment attachment. And then you're going to have a hearing before the court in which you argue that the requirements for prejudgment attachment have been met. And if the court agrees with you, the court's going to set a bond. And upon setting the bond and upon the plaintiff filing the bond or furnishing the bond, the court will issue an order for prejudgment attachment. Now, the bond needs to be an amount of money that's going to be available to protect the defendant in the case that it's later discovered that the attachment was either improperly issued or the plaintiff fails to get the judgment against the defendant that it contends it's entitled to receive. So in the event that any of those things happen and the defendant has been harmed through the deprivation of their property, that bond will be available to satisfy their damages. So in addition to furnishing a cash bond, the plaintiff also needs to have a corporate surety, typically sign on their behalf, and essentially as a guarantor. Often this is an insurance company or other company that provides bonds. And once the bond is posted, the court will go ahead and issue an order to the sheriff to go out and seize enough of the defendant's assets and lock them down so that they will be available once your eventual judgment is entered by the court. All right, so we'll talk a little bit about garnishment in the context of prejudgment attachment. Now, Lily mentioned garnishment earlier, and that wage garnishment is not available in North Carolina, and that's absolutely correct. But the type of garnishment we're talking about here is a process that's ancillary to prejudgment attachment that allows a creditor to extend their order for prejudgment attachment to property of the debtor that's in the hands of third parties. And typically what we're talking about here are bank accounts. A bank account is the classic example of debtor property that's in the hands of a third party in the form of a debt. The bank account that a debtor has in an institution is technically a debt that's owed from the institution to the debtor. And in this case, the clerk will issue a summons to the garnishee. In this case, in the case of our hypothetical, it would be a bank. And the sheriff would go out and would serve that garnishee with the summons, with the order of attachment, and with a notice of levy, informing the bank that the sheriff has now placed a lien on the property in their possession, in this case, the bank account, and notifying the garnishee that they have 20 days in which to file an answer with the court indicating whether they do in fact hold any debtor property such as a bank account, or if they know anyone else who does. And if they do, then that property will be held pending the outcome of the action and will be available for the creditor to resort to once they obtain their eventual judgment. And in many cases, this is done ex parte, meaning you file your application for prejudgment attachment and have the hearing and do all of this without notifying the debtor, so the debtor doesn't have the opportunity to move their bank account somewhere else, such as out of state or liquidate their property. So that's prejudgment attachment in a nutshell. Prejudgment attachment is not available in every case. It's only available in the cases of certain types of defendants. But if it is, it's a very powerful tool to prevent the dissipation of assets. It can provide you with substantial leverage over a debtor if you have locked down their bank accounts and they don't have them available to use them in their business. And it's also available in more cases than you might think. It is, in today's day and age, there are many companies that might be located in North Carolina and operate in North Carolina, but perhaps they're organized in Delaware or Wyoming or some other state. And if they are, then you can use that as a basis to get prejudgment attachment against their property in North Carolina. And a significant benefit to prejudgment attachment is that the lien that you get on the debtor's assets will relate back to the time of attachment. So if there are other creditors suing your debtor and also trying to obtain liens against their property, and you have taken the steps to get prejudgment attachment first, then your lien will actually oftentimes have priority over their liens. So that can be a significant benefit to prejudgment attachment. You just want to make sure that prejudgment attachment is warranted and justified, and then you have good grounds to obtain it. Otherwise, the bond that you do furnish to the court could be at risk if it's later found to have been issued improperly or you don't obtain a judgment. So that's the essence of prejudgment attachment. And I'll go ahead and hand it back to Lily now to talk about transcribing or domesticating judgments.
Thanks, Norman. And just to give you another example really quickly of a way that you can use garnishment outside of the bank account context is if you have a business that is doing business in North Carolina, like Norm said, but is actually an out-of-state company and can't find them here, but they've leased property. Property that's in possession of a landlord is also property that you may be able to reach through the prejudgment attachment and garnishment proceedings. And so really good thing to think about if you have an out-of-state borrower or a borrower that's at least incorporated out of state, primarily has its business conducted out of state, to think about that as an option before you obtain your judgment as a great way to have a lien on additional collateral. But now we've reached a really exciting point. You have a judgment. And so a judgment gives you certain rights and powers. And so what do you do with that? Well, first, you're going to serve that judgment. So you have to serve the judgment debtor within a certain time frame once a judgment is entered. Typically, that involves mailing the judgment with sufficient postage to the judgment debtor within 3 days. Sometimes there are a few different time frame differences, but basically you are going to want to serve that judgment on the judgment debtor as soon as possible. The judgment debtor then has 30 days to appeal a judgment. And that 30 days begins on the date that the judgment was entered. So while you have to serve it within 3 days, the time for appeal, that clock immediately begins ticking the day that the judgment is entered. And so if no action is taken by the debtor in those 30 days, you have a final judgment. And then you have a couple of other options. Transcription. Transcription can actually be done the moment that you obtain your judgment. It's the process by which a judgment is filed within other counties in North Carolina. But you can also wait until the judgment is final to transcribe your judgment. Transcription costs $10 per county. So if you have a judgment debtor who has property in multiple counties, you can transcribe that judgment to enable the sheriff there to eventually act pursuant to a writ of execution, which Norman will get into a little bit later, or writ of possession to obtain collateral or property that can be used to satisfy your judgment that might be outside of the initial county. So for example, let's say I obtain a judgment here in Pitt County, but I think that my collateral is actually located in Craven County, just a little bit down the road. I want to go ahead and transcribe that judgment to Craven County because that's where I think my collateral is. And let's just say that the judgment debtor also owns some property down there. My judgment will attach to that real property in those other counties. And so then I will have a judgment in Pitt and Craven that's attached to any real property owned by my judgment debtor, as well as the judgment transcribed where I think that my collateral is located. The process by which judgments are filed in other states is called domestication. And so I'll talk to you a little bit about the process of domestication into North Carolina. But as I'm only licensed to practice law in North Carolina, I cannot give you a full overview of the domestication process in other states. In North Carolina, domestication requires a final judgment. And so what that means is that you cannot domesticate a judgment until that 30-day appeal period is over. Other states may have longer appeal periods. And so, for example, you may have to wait 60 days or 90 days before you can transcribe a judgment to North Carolina and it be considered final within our courts. And once you have that final judgment, you can take steps to file the judgment in the county where you believe that the judgment debtor is located, and you'll work with the sheriff and the clerk's office to file the necessary documents and serve the judgment debtor with a copy of that judgment. And then the judgment debtor, just like the judgment debtor would if the judgment were initially entered in North Carolina, is going to have certain rights that Norman will jump into, and I will turn it back over to him to get started on execution.
Thanks, Lily. So first of all, we're going to talk about execution. Execution in North Carolina is once you have judgments requiring a debtor to pay money or deliver personal property to a creditor are enforced through execution. That's the name of the legal process. And it involves the clerk of court issuing a writ to direct the sheriff in the county in which the debtor or their property is located to take a particular action. The first type of writ that they'll issue is called a writ of possession. And it's issued by a clerk when a judge enters a judgment that states that a secured creditor is entitled to possession to certain personal property collateral, such as equipment and door, a vehicle, or what have you. And the writ of possession directs the sheriff to go out and actually obtain possession of the property from the defendant and put the creditor in possession of that property so that they can sell it. Pursuant to their security agreement and the UCC. Essentially, a writ of possession is the means by which a creditor's lien on collateral will ultimately be enforced if the debtor does not voluntarily surrender the collateral either before or after a judgment is entered. The second type of writ that's issued by a clerk of court is called a writ of execution. And the writ of execution is issued by the clerk when the judge enters a money judgment in favor of a creditor, saying that they are entitled to the payment of money from the debtor. And it directs the sheriff to go out and serve the debtor with the writ. And if the debtor does not voluntarily pay the sum that has been ordered, then it authorizes the sheriff to seize enough of the debtor's property in order to sell it and satisfy the creditor's judgment. Typically, the sheriff will seize personal property first, and then if there isn't enough personal property, then it can resort to seizing real estate and selling that to satisfy the judgment. All right, so moving on to the exemptions process. If your debtor is an individual rather than a corporation, and they are a North Carolina citizen or a North Carolina resident, then they have a right to designate certain property that they own as being exempt from execution. This is essentially the debtor's right to set aside certain property so that following an execution proceeding, they won't be left entirely destitute and without any property in which to support themselves. And they designate exemptions by filing a motion with the court, setting aside their exemptions. And the creditor is required to provide the debtor with notice of their right to designate these exemptions. And the means by which you do that is you request that the clerk of court issue a notice of right to have exemptions designated. And then the creditor will serve that notice of rights along with copies of the form motion to claim exempt property upon the debtor, either personally through the sheriff or via certified mail return receipt requested. And once those documents are served upon the debtor has 20 days in which to file them with the court and designate their exemptions. Now, at this point, they're also supposed to serve this motion upon the creditor, so the creditor has notice of it. Oftentimes, they do not. Which is why when we're representing creditors, we will check the court records throughout that 10-day period in order to see if a motion, or that 20-day period rather, to see if a motion to claim exempt property has been filed. And if it has been filed, it's important that the creditor review it promptly and determine whether or not it is proper, because if it's not, a creditor has 10 days within which to object to that motion. And if a creditor does determine that the debtor has filed an improper motion, either by overreaching and attempting to designate too much property as exempt, or failing to disclose certain property, or just not filling out the form correctly, then the creditor may want to file an objection and schedule a hearing before the court, at which time a judge will review the motion and then issue an order on exemptions. Now, if the creditor doesn't file, well, first of all, if a debtor doesn't file a motion, then they've waived their right to exemptions, and a execution will issue allowing the sheriff to execute on whatever property the debtor might own, regardless of whether or not it could have been the subject of a valid exemption beforehand. If there have been exemptions designated and the creditor doesn't object, or the court issues an order designating the exemptions, then an execution will issue subject to those exemptions, and the sheriff will be able to go out and execute on the debtor's property, everything except for the property that's been designated as exempt. All right, so just the next slide are just some examples of some of the exemptions to which a debtor is entitled to. They're actually, in the grand scheme of things, by today's value, relatively modest. $3,500 in the value of one motor vehicle, $5,000 worth of household furnishings, plus an additional $1,000 for each dependent, up to a maximum of $4,000. $2,000 worth of tools of a debtor's trade. So if they're a contractor or something like that, they can set aside $2,000 worth of tools. And then $35,000 in the value of a residence or burial plots, and that goes up to $60,000 if they're unmarried and over 65 years of age. So there are some other exemptions as well, but these are some of the common ones and the ones you'll see. In theory, when you're talking about, for example, $3,500 in one motor vehicle, if a debtor owns a very valuable vehicle, such as, let's say a Lexus worth $20,000 or something like that, in theory, the sheriff would be able to seize that vehicle and then sell it and distribute the first $3,500 to the debtor, and then pay their own expenses and commissions, and then distribute the rest to the secured creditor or to the judgment creditor. So that's the way the exemptions process works. I will talk a little bit about liquidating debtor assets for your benefit. There's two regimes. We already touched upon a sheriff's sale, essentially. There's also the UCC Article 9 sale. The UCC Article 9 sale is the creditor's own sale of repossessed collateral, whether that occurred before or after judgment. This is in contrast to the sheriff's execution sale, which is the sale of debtor property pursuant to a judgment entered by the court. So going to the next slide, talk a little bit about sheriff's execution sale. Again, this is the method by which you're enforcing a judgment lien. It can be enforced against real or personal property. Typically speaking, the extent of enforcement is really going to vary a great deal from county to county. And a creditor with a judgment should expect that going in. Some sheriffs in some counties are very incentivized to be helpful and execute on debtor property. Sheriffs do earn a commission on the sale of debtor property. It's 5% on the first $500 and 2.5% on all amounts over that. But in most cases, I'd say the vast majority of cases, what a sheriff is willing to do is relatively limited to what legally they could do. They're not going to be going into people's homes and looking at the artwork on the walls. They're not going to be selling things that are titled if the title is somewhat muddy or unclear. The sheriff's really going to be looking for assets that are easy to identify and sell, such as real estate, vehicles, boats, jet skis, things like that. That's typically what a sheriff will go after. And in most cases, a creditor can really improve their chances of recovering something from a sheriff's sale by taking an active role in searching for debtor assets and then handing it up to the sheriff on a silver platter and say, we're aware of these vehicles and this real estate that is owned by the debtor, and we're requesting that you specifically go out and execute on these assets, rather than leaving it up to the sheriff to identify those assets for you. All right. So the next type of next slide, please. The next type of sale is, of course, the UCC Article 9 sale, and this is the creditor's own sale of their own collateral that was voluntarily granted to them under the security agreement that secures their loan. And in the case of personal property, we're talking about vehicles, equipment, inventory, that sort of thing. The procedure for the sale and distribution of the proceeds is governed by the UCC, and the UCC, although it's governed by the UCC actually grants a secured creditor pretty wide latitude in the method by which they sell their property or their collateral, as long as that sale is commercially reasonable. And the UCC specifically says that every aspect of the disposition of your collateral, whether it be the method, manner, time, place, and other terms of the sale, must be commercially reasonable. And commercial reasonableness is really a case-by-case judgment on the part of the creditor. If the method by which you're liquidating your collateral would be defensible from a business standpoint, then typically it's going to be considered commercially reasonable. Just because you could realize a higher value for your collateral if you took more time to sell it or sold it in a different manner, doesn't necessarily make that disposition commercially unreasonable. But because you can't ultimately control the price at which the collateral is sold necessarily, a creditor should take care to make sure that everything else about the sale is above board and defensible from a business standpoint. So if you do, just understand that if you do, for some reason, your collateral does realize a low price at liquidation, and the debtor challenges that disposition, that it will be subject to greater scrutiny as to the method that you chose to liquidate that collateral. So if you're selling something like a vehicle or expensive equipment, consider a public sale with competitive bidding and appropriate advertising. Consider retaining a reputable auctioneer to sell it. If you want to sell your collateral for some reason by private sale, you should definitely consider getting multiple offers so that you can have the option to choose the highest one, and it will be more likely to be considered commercially reasonable. And definitely, if the collateral needs to be cleaned up or if there are some inexpensive repairs that can be made, those should be considered, so that it will be clear that the creditor did everything that they could in order to realize the best possible price. All right, so the next slide, please. Just really quickly, I think most creditors realize this, but you are required under the UCC to provide your creditor or your debtor and certain other parties with prior notice of your intent to dispose of your collateral. Under the UCC, you need to provide them with certain basic information about the collateral, the method by which it's being disposed of, their right to an accounting, the time and place of any public sale, or the time after which a private sale will be conducted. Probably more importantly, besides what's in the notice, is who the notice is going to. Definitely the debtor is entitled to notice. If the owner of the collateral, if they're different than your debtor, is entitled to notice. Any guarantors or other secondary obligors are entitled to notice. Any third parties from whom the creditor has received notice that they have an interest in the collateral is entitled to notice. And any other third party that has a perfected lien in the collateral is entitled to notice. So if you sometimes if a creditor has repossessed collateral through self-help means or perhaps not involved counsel, you really need to remember that before you turn over that vehicle or whatever to an auctioneer, you have an obligation to run a title search and make sure that there are no other third parties entitled to notice of your disposition, including the IRS. So you should discuss that with your auctioneer and or counsel to make sure that all parties who are entitled to notice of the disposition under the UCC are receiving notice. All right. Finally, I just want to note that the debtor, any guarantor, or any other secured party who has a lien in your collateral is entitled to an accounting of the secured debt and ultimately the right to redeem the collateral by paying the secured debt and all of the creditor's expenses of repossession, and in the case of a loan where counsel's been involved, attorney's fees up to 15% under North Carolina law. So with that, I'll turn it back over to Lily to discuss fraudulent transfers.
Thanks, Norman. And before we jump into fraudulent transfers, I just want to talk to you about what happens when it's not all sunshine and roses, right? Norman walked you through the process of, we know where the property is. We're going to get that property. We're going to sell that property and we're going to be paid back. And that's awesome. And we love when that happens. But sometimes it's a little difficult to discern what exactly is out there that the sheriff can pursue. And, how do you navigate figuring out where things are or if they exist at all? And so I just want to talk about a couple of tools that are available to assist you in that process. The first is an asset search. And you can do this yourself. You can do this with your counsel. And oftentimes sheriff's offices will do their own version of an asset search as well once they have received a writ of execution or possession. Typically, they conduct asset searches in conjunction with that writ of execution because there's additional property that they may need to levy upon to satisfy your judgment. But that involves looking at, information that's available on various databases. And so it can involve searching, DMV records, records of the Secretary of State, and other databases that are available that kind of let you know things that may have been owned in the past by your judgment debtor. If they own property, you can run certain property searches. And when I say property, I mean real property, and kind of try to learn where they might be living or where they may own additional property. So a common example of this is they have a lake house or they have a beach house. And you want to make sure that you're aware of that ownership and can domesticate or transcribe your judgment to whatever county that residence is located in. But let's say, you've run asset searches and you're not coming up with a lot. What else can you do to learn about assets of your judgment debtor? Well, under North Carolina law, you can actually issue post-judgment discovery to your judgment debtor, and they are required to respond to that discovery. And so that's what we call supplemental interrogatories. And those are just questions to the judgment debtor about their assets, about their property. We can ask some other questions related to property ownership. And then you can also request documents. And so a common example of this is tax returns. If you have a corporate debtor and then they're saying, well, we're insolvent or we don't own any property, a good thing to do is review tax returns that will tell you if that is true or not. And so you can request that information from the judgment debtor pursuant to that statutory process. And if they don't respond, you can let the court know that they haven't responded and you compel a response, requiring them to appear and say why they haven't responded to those interrogatories. And so that is a great way to get them to provide you information if historically they have been reluctant to do so or difficult to deal with. Another option is requiring third parties to appear and answer about assets of a judgment debtor. And this is typical when there are, as Norman suggested, maybe your borrower doesn't own the collateral. And so maybe it's in the possession of a third party for whatever reason. You can, under North Carolina law, require those third parties to appear and answer about that collateral, provide you with information. And that's just another thing to have in your toolkit if you are dealing with an evasive judgment debtor, which I'm sure none of you have ever dealt with before. And so speaking of evasive or otherwise sketchy situations, we'll jump right into fraudulent transfers to wrap up our presentation today. And so first, let's talk about what makes a transfer fraudulent. Of course, you immediately think when you think fraudulent transfer, at least I do, okay, bad, someone intended to defraud someone, and then here we are. Under North Carolina law, there is a requirement for fraudulent intent and insolvency to have a fraudulent transfer claim. North Carolina has what is called the Uniform Voidable Transactions Act. And North Carolina adopted that in replacement of the Uniform Fraudulent Transfer Act. Pretty similar, almost identical, just a couple of new terms of art in that statute. But it requires that you show that there was insolvency, and so either the inability to pay debts as they became due, or an insolvency resulting from that transfer, as well as an intent to make that transfer to conceal or hide or otherwise get rid of some assets. However, intent is not always required for fraud. And we can jump into that a little bit later. But basically, you've got a couple of options for recovery for fraudulent transfer. Like I said, you have a state law claim based on North Carolina's Uniform Voidable Transaction Act. And if you're in another state, most likely they have either this version of the act or the Fraudulent Transfer Act. And so you're going to have a cause of action that's pretty similar to what you would have in North Carolina under state law. If your judgment debtor at any point files for bankruptcy or is a party to an involuntary bankruptcy petition, you may also have claims for fraudulent transfer under the bankruptcy code. There are different timelines and time constraints associated with each of these claims. And so they give you the opportunity to recover transfers made within specific periods of time. So for example, in North Carolina, generally, not always, of course, but generally you will have 4 years from the date of a fraudulent transfer to bring an action related to that transfer, or 1 year from when you discovered that transfer, if there was no way that before that time you could have reasonably discovered that transfer. And an example of a fraudulent transfer that may be relevant in the secured creditor context is you've filed a lawsuit. Your prospective judgment debtor knows that the lawsuit has been filed, or you've even sent a demand letter. You put them on notice that, you know, bad things are going to happen if they don't pay what they've owed, you know, the bad thing being the filing of the lawsuit and the process we've discussed today. Well, they receive that demand letter and they decide that now is the time to transfer some of their real property from being owned individually to owned as tenants in the entirety with their spouse. And the significance of that is that in North Carolina, if property is owned by spouses, your judgment is not going to attach to that property because it is owned by what is called tenancy in the entirety. So if you can prove that the now judgment debtor made this transfer with the intent to make that real property unavailable to your judgment attachment, you'll have a claim for fraudulent transfer. And that is, of course, if you can prove all of the elements required. So I left out some key facts there. But basically, if there's an act that has been taken and it involves the transfer, concealment, or squandering away of assets to make them unavailable to you at a time when the debtor is unable to pay its debts as they become due, or as a result of doing all of that, no longer has any assets by which it can pay its debts. Those are going to be situations where you will have a viable fraudulent transfer claim. And like I said, those are going to be focused on transfers within a specific time period. And then tied to that time period, you'll have to bring those actions within a certain time frame. And so if the debtor did something 20 plus years ago, you may not have a viable fraudulent transfer claim depending on the facts and circumstances of the case. Generally going to be 10 or fewer years either under the Bankruptcy Code or North Carolina's Uniform Voidable Transaction Act for you to undo those fraudulent transfers. And Norman, I just want to give you the opportunity to jump in on everyone's favorite topic of fraudulent transfers to end on a really exciting note here.
Actually, I don't have any. I don't have anything to add to what you already said it so well. But we probably do have a couple of questions here, I think, to in the Q&A box to go through. So maybe we could do that. So the first, does that sound
Perfect?
Okay. So Vince had a couple of questions about number one, I think asset-based lending, and particularly what it looks like to me is maybe questions about factoring and the sale of receivables in North Carolina. I think the question is whether if an asset-based lender has a purchase and sale agreement in which either Texas or Louisiana law is agreed upon by both parties in the contract, is the fact that both states have laws that if a contract says if it was a true sale of accounts receivable, will North Carolina court understand this agreement and allow for the stay to allow the purchaser of accounts to collect its AR? I think what he's asking, I think what this question is asking is whether or not a court would stay a creditor's judgment enforcement against accounts receivable to allow the factoring company to collect its AR if it has a contract based on Texas or Louisiana law. And my answer to that is, I don't know. I've never encountered that situation. I could look into it a little bit more. I suspect that if a judgment creditor is trying to execute upon accounts receivable in North Carolina, that's going to be done in a supplemental proceeding, which is similar to garnishment, in which those third-party account holders would have to come in and answer to whether or not they, in fact, owed a debt to the debtor. And I think I've never seen that done in North Carolina, because typically in an AR setting, you have a high number of ARs owed by individual customers of a particular debtor, and it would be pretty cumbersome for a judgment creditor to haul all of those third parties into court to collect that AR. I think it would typically be done through a receivership. And as far as how a North Carolina court would understand Texas or Louisiana law in that situation, I'm really not sure, but I'm happy to entertain that question by email separately. He also asked, there's also been a question asked about, if we have a judgment, can we go through a process and hire a truck and show up to an affluent debtor's house and load up property, accepting exemptions such as jewelry, china, antiques, furniture? If so, that would be great news. It would be great news. I think the answer is probably no. If you're attempting to execute on debtor property via judgment, and you have a sheriff showing up to their house, they're going to ask the debtor if they have any non-exempt property. They're probably not going to go into their house. They're not going to independently value the value of that debtor's property or scrutinize their exemptions. The way to get at that kind of property is to do what Lily said, as far as to go through a supplemental proceeding, sit the debtor down, depose them about what property they own, serve them with interrogatories about what property they own. If they identify specific furniture, jewelry, that sort of thing that doesn't fall within exemption, then you can get a court order to require a sheriff to go out there and execute on that specific property. Here's another question. If a judgment debtor has interests in a limited liability companies where he or she is receiving money, income, profit through the LLC, is there any way a sheriff can seize that money to pay towards a judgment? Yes, that is called a charging order. So basically, if a judgment debtor has an LLC interest, you can go back to court after you get your judgment, and you can ask the judge to essentially enter a charging order against that judgment debtor's interest in the LLC, and that will operate as a lien against the interest in the LLC. And once that order is served upon the LLC has an obligation to make any distributions of profits or that sort of thing to the creditor instead of the judgment debtor. Now, the caveat there is that it has to be a distribution of profit. You are not going to be able to get at any kind of wages or similar compensation that is paid to the judgment debtor by the LLC. If the judgment debtor is an employee of the LLC, then those earnings, if they're legitimate, are off limits to the judgment creditor. And also, there's no rule that says that the LLC must issue distributions to a judgment debtor for the benefit of the creditor. So if you're talking about a closely held LLC, there's just a couple of members and they're not distributing any profits on a regular basis, then a charging order might not be of much value. Lily, do you have anything to add to that?
No, I think you covered it and made a great point that depending on how the LLC is structured and the savviness of your judgment debtor, a charging order may be limited in its effectiveness just based on how money is distributed by the LLC, if it's profit or if it's a membership distribution. Of course, that doesn't mean it's not worth pursuing a charging order. Sometimes, making the judgment debtor come to court for all of these matters. Eventually, they will just decide that they don't want to come to court anymore, and maybe they will pay you. Of course, best case scenario, but I think that it is important to keep in mind when you're making decisions that how those LLCs distribute money may change after you obtain a charging order.
Right. But as you said, definitely worth doing, just so that if there are other members and there are distributions being made, you have at least have an argument that you have a right to intercept those distributions.
Absolutely. And it's a pretty simple process on the secured creditor end. It's not a very heavy lift, but it is a very effective tool to kind of create additional leverage on the judgment debtor.
Yes.
Well, thank you guys so much. We're right at 1 o'clock or a little bit after. So thanks for everyone for sticking with us. Thank you so much, Norm and Lily. That was wonderful and just a great conclusion to our special asset summer school series. For those of you in attendance following this webinar, probably in the morning or sometime tomorrow, you'll be sent an email with the link to this recording as well as these slides, as I know that there was a lot of really good information and Lily and Norm worked really hard on them. We're so thankful for your participation, and I hope that you can utilize this knowledge to enhance your business and organization in the future. Once again, please stay tuned for other webinars as well as this summer special asset summer school series next summer. Thank you so much. And that is going to conclude today's webinar. Thanks, everybody.
Thank you.
Thanks.